You're going live in 5, 4, 3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good morning, lawyers. Before we start, just a couple of things to you. If technology has been working very, very smoothly, so we don't anticipate any problems, but if we should have any difficulties, we'll just take a short pause and we'll resolve them. And we're aware that some of us are from offices and some from homes, and so if children or pets make an entrance, don't worry about it. We'll work through that. Call the case, please, Mr. Hebner.
Curtis Pierce et al. Versus State of Tennessee.
We'll hear from the appellant.
Thank you, Your Honor. May it please the court, my name is Christopher Smith, and I represent the Pierce family in this case, and I'm honored to have the privilege to appear, if virtually, before the Court of Appeals for the first time, even if it is only in my office here. This is a tragic case. It arises out of the Claims Commission. As you probably know by now, Stephen Pierce was a 2-year-old boy who drowned at a state park. But because this case turns on application of the recreational use statute, which is a rule of general applicability, not limited to governmental entities, this case will have far-reaching consequences. And an overly literal interpretation of the recreational use statute would apply the defense to commercial businesses, for example, amusement parks operating in the state's largest cities. And under the right scenario, the statute could apply in theory to the Tennessee Fairgrounds, even the largest arenas in Tennessee, as long as an argument could be made that the plaintiff was engaged in some recreational activity. And the list of those activities is non-exhaustive and also constantly expanding. And it seems like every time a case comes up involving that provision, that list does grow. So that's why we use the image in the briefing of the blue whale swallowing the common law of negligence, potentially lowering the standard of care throughout the state of Tennessee, allowing landowners to assert this defense in contexts where it was never intended to apply. The state's argument admits of no limitations to the recreational use statute. And just to back up, there is no limitation for population or acreage or commercial transaction. The statute would apply in seemingly many, many different contexts, unless there is some sort of limitation on it. And we submit that there are two different kinds of limitations. And the first comes from the parent versus state case, the key Tennessee Supreme Court case on the recreational use statute. And in that case, the court recognized, quote, limitations to the immunity defense seemingly beyond the statutory exceptions. And that's at 243 in that case. So in announcing the sort of two-part test for whether or how the recreational use statute applies, part 2 of that test examines whether, quote, whether any of the statutory exceptions or limitations to the defense are applicable. And so we're submitting that that's kind of like a judicially recognized, common law recognized exception to the recreational use statute beyond even the statutory exceptions. And an example of how that might play out was in the Wilkerson case, which is a Tennessee Court of Appeals case, Wilkerson versus Altizer, where the court said that the issue was, quote, the duty owed to a social guest by a social host, and that the condition of the premises were not at issue. In that case, the plaintiff was injured when a boat was capsized on a pond or a lake on the landowner's property. Seemingly should fall within the recreational use statute, but the Court of Appeals said, well, look, this is really an issue of social guest, social host liability, a different duty. The persuasive authority we cite on this is very robust. The Supreme Courts of Ohio, Wisconsin, Idaho, New Jersey, Iowa, Texas Court of Appeals, and the Fifth Circuit applying Louisiana law, all cases in which the courts recognize limitations to the immunity, even without specific statutory provisions limiting that defense. And I just want to pick up on the last one there, the Louisiana case. In that case, the plaintiff was a child who was fishing on the landowner's property. And on his way back from fishing, he saw a pile of what looked like leaves or dirt, and he jumped into it. It turned out to be chemical ash, and he was severely burned. So the court had to look at, well, what's the interplay between recreational use immunity and the doctrine of attractive nuisance. Does the recreational use defense abrogate attractive nuisance? And the court held it did not, even though, of course, there was nothing specifically in the Louisiana recreational use statute accepting attractive nuisance. So that's sort of the common law, judicially recognized limitations. And just to back up there, this is a statute in derogation of the common law, and therefore under the canons should be strictly construed. Setting that aside, we submit that there actually is a specific statutory exception, and it's the one that unfortunately has never been interpreted by a Tennessee appellate court, and that's the subsection A2 below the gross negligence exception. And just to kind of set this up, Tennessee's recreational use statute was first passed in 1963. That's 2 years before the Model Act passed by most other states in 1965. So this provision 70-7-102A was added by Senator Thomas Boyers at the literal 11th hour, as we put in the briefing and in our legislative history materials. Thomas Boyers was the former city attorney of Gallatin. He served as a judge for the 18th Judicial District, and his dad was a judge. He actually filled his dad's seat. So he stands up at the literal 11th hour, as I say, and he says, wait a minute, this bill, as passed, is, quote, so broad it might have affected liability of landowners to licensees, guests, invitees, and the language amending the latter part of the bill is merely to clarify it. So he says, wait a minute, we cannot have this over literal interpretation. And that's what this provision A2 or 102A was supposed to address. So the way we read that, and this is clearer in our brief at page 29, but is that the recreational use statute does not limit liability that otherwise exists for injuries to persons to whom the landowner owed a duty to keep the land or premises safe or to warn of danger. In other words, pre-existing or other legal duties different from the common law landowner duty are unaffected. So social guest and that sort of thing. What does this mean in the context of this case? Well, we allege in the complaint that the recreational use statute does not apply to the following actions. Probably most saliently, the providing of conflicting rescue instructions in an emergency situation. A key part of this case is that the Rangers told the Pierce family to go down the path of the river, and they were still in danger. And then the Rangers changed their instructions and told people to seek high ground instead. So we're saying, well, that's an act of human agency, which, as we'll get to the act of God, force of nature point, but that's an intervening act of human agency. And it's also active negligence of the landlord. If the landlord just allows people passively to enter the land, that's one thing. But where the landowner then engages in active negligence on the property, that's another reason that this doesn't fall within the recreational use statute. There are other examples, such as failing to implement the warning system, failing to provide life jackets in a reasonable manner, opening the park that day and keeping it open despite the knowledge that rain was coming. And if this were a GTLA case, maybe we wouldn't be able to argue that under the discretionary function immunity. That doesn't apply in claims commission cases. Finally, failing to follow TDEC regulations is another one. And that gets into the Stewart versus State case, where the Supreme Court looked at whether other statutes or regulations created a duty of care for purposes of the jurisdictional prong, negligent care, custody, or control of persons. So turning now to that, we submit that the Rangers owed an affirmative duty of care. The state argues otherwise. Obviously, we have a disagreement on that.
Counsel, let me interrupt you a second.
Yes.
Sorry. Did the complaint allege that the ranger gave that the father and the child did not start down the trail back to the trailhead until the ranger told them to go back?
Yes, Your Honor. The complaint alleges that the park rangers blew their whistles. It was an emergency situation, and then the plaintiffs, Curtis and Stephen Pierce, headed down the river in the path of danger.
Does the complaint allege that the park ranger instructed them to head down the river?
Yes, Your Honor, it does. It does. And I don't actually have it right in front of me, but get it when we break for the rebuttal, but it does. And I would just submit, to the extent there's any factual, that it could be that case. We're here on a Rule 12 motion. We should be able to go and prove this up and get discovery on exactly what those instructions were and how that all played out. Anyway, the affirmative duty, back to the point, is the State versus McCormick case, which is actually a community caretaker case, but the Tennessee Supreme Court recognized that officers are charged with the duty to protect people from accidents and natural perils. The citing of the Lee versus State case out of Alaska, which the Tennessee Supreme Court cited with approval in the Lindsay versus Miami Development Corps case. These are cases recognizing an affirmative duty of rescue. And then, of course, there's the question of, well, even if there is no affirmative duty, did they assume it when they gave the rescue instructions, when they blew the whistles, when they issued the warnings? And the Stewart and Mullins case both recognize that the Claims Commission may, on the right set of facts, exercise jurisdiction over a claim for an assumed duty of care. Now, the Rangers controlled the plaintiffs here in this case in the sense that they issued them commands which the Pierce family obeyed. And incidentally, that might even give rise to a Fourth Amendment seizure under those facts, which would, of course, create its own duty under that framework. Turning quickly to where we submit that the Claims Commission got this wrong, the clearest instance, we think, is that Parent versus State clearly held that plaintiffs are not required to plead the recreational use statute exceptions. We are not required to plead gross negligence. More recently, in McCaig versus Whitmore, a Tennessee Court of Appeals case, which I believe Judge Golden was on the panel, and that one observed a party is not required to specifically plead the exceptions. Now, gross negligence is ordinarily a question of fact. It may be decided on the summary judgment at the summary judgment stage, as McCaig was, but that's only after the benefit of discovery on the issue. And neither the Claims Commission nor the state cites a single case decided at the Rule 12 stage dismissing a complaint for failure to plead gross negligence under the recreational use statute. And the reason is clear. Parent clearly said you don't have to do that. Even so, the Claims Commission went a step farther and said, well, there also is no gross negligence on these facts. We submit that was in error because of the Rucastle and the Sumner cases, both of which support gross negligence on these facts. And just to draw an analogy to Sumner, that was unexploded ammunition in the ground at Fort Campbell, and the plaintiffs were injured by that. We submit that this case is essentially a bomb in the ground waiting to go off. It just happens to be a flash flood that, under the right circumstances, is a fatal, lethal instrumentality. And of course, the key fact is that the state knew that people had died by flash flooding at this exact spot. They knew they needed a warning system. They said they were going to do it. They knew the warning system would provide 2 hours of warning time and would save lives, and they just didn't install it. And under the authorities, that is, there is a reasonable fact finder could conclude that is gross negligence. And there's persuasive authority on that as well. We cite cases out of Nevada, Oregon, and Illinois. I'm running out of time here, but I just wanted to get to...
Is the force of nature defense a defense to gross negligence?
Yes, Judge Golden, the force of nature defense negates the gross negligence exception. It does not negate what I call the Boyer's Amendment exception, or the other duties, the subsection A2. But it does negate the gross negligence exception. So to the extent that this is a force of nature, that would be negated. Now, of course, we say it's not a force of nature because it was foreseeable. It could be avoided. It could be prevented. You could have had 2 hours warning time. And of course, this issue of the negligent rescue instructions is an intervening act, akin under the case law to the negligent construction of the culvert or the roadway. This is human agency is intervening here in addition to the water itself. So I think I've run out of time, and I'll pause for rebuttal.
Thank you.
You have your time for rebuttal. We'll hear from the appellate.
Thank you. May it please the court. I'm Heather Ross. I'm a Senior Assistant Attorney General for the state of Tennessee. And I do agree that the facts in this complaint are tragic. Accepting those facts as true, the Claims Commission properly dismissed this case for 3 reasons. First, the recreational use statute does apply to this premises liability case. Therefore, the landowner, and no exceptions apply, therefore the landowner, the state, is not liable for the injuries caused by a force of nature, this flash flood. Secondly, the claimants were not in the care, custody, and control of the rangers at the time that they did not avoid those powerful flood waters and get to higher ground. They were actually outside even the hearing range of the rangers. Therefore, there's no
Counsel, let me go ahead and interrupt you there on that point. But had they started down the trail because the ranger had told them to?
According to the complaint in paragraph
according to the complaint, that's all
yes,
we're looking at right now.
Paragraph 35, they had left the waterfall prior to the rangers blowing their whistles. They were actually in front of their travel companions. But even so, even if they had left the waterfall because of the instruction, although the complaint does not say that, but even if they had, that general instruction was an instruction by rangers to evacuate the area, the park, during an emergency situation when the situation was changing drastically. Those instructions were not directed to Curtis and Stephen Pierce specifically and only. Those were instructions that the rangers gave to everyone to evacuate the area. That does not make everyone in the area within the care, custody, and control of the rangers. In fact, the complaint alleges, it is taken as true, that it's over a mile from the trail waypoint up to the waterfall. The rangers were just evacuating everyone. But not only does the recreational use statute apply, no exceptions apply either. So taking the facts as true, this was properly dismissed on a motion to dismiss. As I indicated, because Mr. Pierce, Stephen Pierce, were not in the care, custody, and control of the rangers, then the subsection providing a waiver of sovereign immunity no longer applies. There would be no subject matter jurisdiction for the claim at all in the Claims Commission, and then no liability. And for that reason as well, claimant's last claim and a breach of an assumed duty also would not apply because there is no standalone exception for a waiver of sovereign immunity. Now, the recreational use statute specifically takes away the duty that a landowner would have to make their premises safe for people who enter for recreational purposes. It also takes away the duty to warn of dangerous conditions, even if there's gross negligence. If that dangerous condition is a force of nature, then the gross negligence exception doesn't even apply. The state submits that the gross negligence exception never applied in this case because the flash flood, the instrument of injury, is a force of nature. There was no man-made or human hand in that flash flood. It was caused by rain that hit non-porous rock, went down a stream, down a waterfall, and then the narrowing gorge made that body of water extremely powerful and extremely fast. The gross negligence doesn't apply. The Claims Commission did go further though and just noted, and by the way, there was no utter disregard for human safety, the element of the description of gross negligence. And the Claims Commission did go through all the things that the rangers had done throughout the instance. Claimants allege that there is another exception, and that's found in subdivision A2. However, claimants' interpretation is extremely broad and, in fact, would negate the entire recreational use statute, because the claimants would like that exception to be read that the landowner still owes a duty of care to keep the premises safe or to warn of dangerous conditions or warn of possible dangerous conditions, and in fact, according to the claimants, warn of consequences of dangerous conditions. That is not only over-broadeningly reading that subsection, but it would actually negate the recreational use statute itself. Also, in claimant's interpretation just ignores the first couple of words of that exception that says it accepts injuries caused by third parties to whom permission was granted to other individuals. In this case, in this subsection, claimants ignore the fact that the person, the category of person injured, must be tethered to those persons, those third parties to whom permission was granted. One cannot occur without the other. To read claimant's interpretation, not only would it negate the recreational use statute completely, but would also completely vitiate the need for a gross negligence exception. Yet those two exceptions are right one after the other. The legislature would not have created a gross negligence exception and then created another exception that totally vitiates the entire purpose of it, and in fact swallows the entire rule of the recreational use statute. The claimant's next argument that Stephen Pierce and Curtis Pierce were in the care, custody, and control of the state fails for a number of reasons. The factual allegations themselves confirm that the claimants were not in the care, custody, and control of the rangers just because they entered the park. And to that end, I would direct the court to one of those sections, section 103 of the recreational use statute, that clarifies specifically that the legal status of invitee is not given to a person merely because they have entered someone else's land with their permission for the purpose of recreating. Therefore, there would be no special relationship like a hostess and a invited guest. That's specifically excluded from the recreational use statute. And in fact, there are other societal concerns that would suggest or would mandate that there can't be an expansion of that special relationship, because there is a societal policy that an individual is responsible for their own safety, that they can't ignore what is right in front of them, and that they can't not see what is right in front of them.
What about the obligation? What about the obligations that the rangers had that they attempted to exercise? The obligation to inform them it's time to move on, it's time to do something to change your direction. What about that?
Well, recall this was a changing situation. The state disagrees that these were conflicting instructions in any event. They were instructions that were occurring in an emergent situation that was having emergency in different circumstances were occurring, and they were occurring very rapidly. The rangers weren't specifically speaking to Stephen, to Curtis Pierce. They were speaking to the visitors, and to that end, the rangers were not showing gross negligence. They were trying to get everyone out of the water and out of the way of the flash flood.
Well, but is that something to be decided on a motion to dismiss, that they weren't showing gross? I mean, they may have been doing exactly what they should have been doing at the time they gave the instructions. But is that something to be decided on the motion to dismiss?
Yes, Your Honor. The gross negligence, as I said earlier, it's irrelevant because this was a force of nature. Going to the care, custody, and control, however, that does matter because you have to find that there was care, custody, and control of Stephen and Curtis Pierce.
Well,
There was not.
I'm sorry, go ahead.
Even when you look at the allegations in the complaint, Stephen and Curtis Pierce were so far away from the Rangers.
I understand that they had gotten further down the path. But my question is, was that what they were instructed to do? Did the law enforcement official, which is what the park rangers are, instruct them and perhaps others, we need to evacuate, you need to do it now, head for the trailhead. In other words, get on the path. Now, I understand that when the waters really started coming up, they were too far down, they couldn't even hear. But if they were on the path because the ranger had instructed them to, and maybe properly, I'm not saying the ranger did anything wrong, or I'm not saying that the ranger did everything right. I don't think we know at this motion dismiss stage. But if they were on the path because they were instructed to,
that does not matter.
I don't understand why were they not under their control?
They are not under the control. For example, what if someone had wanted to stay in the water and the Rangers had blown their whistles and had said, get out? There is no control of that individual. They can stay in the water if they so choose, just as Mr. Pierce can choose to do. He wasn't in the physical control of the Rangers. Mr. Pierce could get out of the way of the water. Certainly, he could go to higher ground. He could take a different path. He could have not go to the trail.
In other words, your position, he could have ignored what the Rangers were saying. He was perfectly free to have even stayed swimming there if he wanted to. The Rangers would have just said, well, okay.
For the purposes of jurisdiction, waiver of sovereign immunity, the claimants must show that these claimants, not every park visitor, but these plaintiffs were in the physical care, custody, and control of the Rangers. It is not enough that the Rangers just provided general instruction to all park visitors.
I understand, counsel. I mean, I understand you're saying that these were just general instructions, but they were instructions to the people at the waterfall, right? At the swimming hole.
To the people that were in the water area. This, even according to the allegations of the complaint, that was a large area.
Okay. But this father was in that group.
To the extent that he alleges that he had left the water area prior to the whistle blowing, but heard the whistle, yes, you could say that. But that doesn't put him in the care, custody, and control of the Rangers.
All right, make sure I understand that. Is it your position, and I'm going to ask you to assume some things here at this motion to dismiss stage, that if he left, started down the trail path because the Rangers told him, everyone, you need to leave here, and you need to leave here right now, get back to the trailhead. And then he starts down the trailhead. Are you saying that he was never under their control?
He was not under their physical control, no. He could
Okay, they were perfectly free to ignore the instructions of this law enforcement official. I'm not real sure the park rangers want that to be the rule. that people in the park are perfectly free to ignore what they tell them. That's neither here nor there. You don't have to answer that. That's neither here nor there.
That is true, though. They did not have to follow the ranger's instructions.
Is there any proof of that?
There's no proof that they were physically in the control of the rangers, such that the rangers were controlling, caring, or that the claimants were in their custody.
Okay. All right. Thank you, counsel. We'll hear from the appellant rebuttal.
Your Honor, just picking up on that conversation there about care, custody, and control, I just want to stress that it's care or custody or control per Stewart. You read those things in the disjunctive. And to the extent that law enforcement officers are issuing commands in an emergency situation, blowing their whistles, and then people obey those commands. I might stress a discrete subset of people, not everybody in the park, but people in the dangerous path of the floodwaters who needed rescue. And the officers then take the affirmative act of issuing them commands, blowing the whistle. That gives rise to a relationship between them, even if one, as we say, already existed under the affirmative duty just generally. But even setting that aside on the specific facts, again, there's no proof of anything under Rule 12 here. There's only, could this be, as we allege it, right? Could there be a set of facts under which this is true? And I think obviously, yes, it could be. But just to emphasize the point, they did issue the commands. They were under the duty of care. And there was also this issue of control. And we submit it's like the Bird case where if you must prove physical control, if you're directing people's movements under the penalty of law enforcement, that's control and should give rise to jurisdiction. Just real quickly on why this is not an act of God. There are cases involving rainfall. There's the Glover versus Hardeman County case where the court said under the proof, the amount of rainfall experienced was foreseeable. There was material evidence the defendants were negligent in constructing the culvert. And so we're saying, look, obviously this was foreseeable. You knew that it happened before and knew it was going to happen that day because the weather service had called. And then these rescue instructions are human acts of human agency that increase the danger, again, under one set of possible facts to which we should be entitled at Rule 12. So that's it. And I thank you for the time.
Thanks to counsel for both sides. We appreciate your briefs and your oral arguments. You've made the issues are clear and both sides' positions are clear, and we appreciate that. If you would, Mr. Hibner, recess court until our next